All right, so why should I give him 5 years? The complainant in this case is the same complainant that he has the new case on.
There was some other things going on in his home life and stuff. I believe he's had some family health issues and stuff.
No, I mean, because he hasn't learned anything. And I don't know what's happening in his relationships, but it doesn't appear he's learned anything. And I don't know why I should sentence him to just 5 years. All right, the court is going.
This man walked into court believing 5 years was a fair outcome for what he did. He truly seemed to think that would close the book on the situation. What he failed to acknowledge is that this wasn't his only case. There was a second assault charge involving the same victim. Even more surprising, he appeared to believe both cases should be handled together, almost as if they were one single incident. As Judge Boyd began reviewing the details, the mood in the courtroom quickly changed. This wasn't a one-time mistake or a momentary lapse in judgment. The record showed a clear pattern. It's hard to understand how someone can seriously harm the same person twice and still walk in with so much confidence. I'm curious what you all think. Should 5 years ever be enough when violence keeps happening, or does repeat behavior call for the strongest possible sentence? Let's take a closer look.
Somebody can almost take out the person they claim to love twice and walk in with this level of confidence. Let me know in the comments if you think 5 years is ever enough for repeat violence like this, or if you think this dude deserves the absolute max. Let's dive in.
Calling 2025 CR 01152. Could I have parties announce?
Your Honor, there's also the MTR.
Yeah, I'm going to take this up first.
Can we do the MTR first?
Why are we doing the MTR first?
Uh,
And are you Mr. Geary?
Yes, ma'am.
Counsel, you received all discovery?
Yes, I have.
Did you review it with your client?
Yes, I have.
Court will find that the state is in compliance with discovery. By entering into a plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea today?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived indictment, freedom of information, and rights under Article 1.051. By information, you're charged with assault family household member with a previous conviction. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. According to the plea, punishment is to be assessed at 5 years in the prison. There's a $1,500 fine. Did you understand that to be the plea?
Yes, ma'am.
State?
There is, with the exception of, I had put restitution, should there be any, I know that he would be entitled to restitution here.
All right, it's gonna be restitution if any. Let me just tell you, if they're sending you to prison and your counsel is waiving a PSI, then whatever that restitution amount that that person claims, that's gonna be the restitution amount. And when you're up for parole, they'll take it up with parole. Do you understand?
Yes, ma'am.
All right, restitution, if any, to Anessa Nicole Guerra. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated primary custodial parent?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Your Honor, at this time, state orders into evidence, states exhibit 1 with all attachments.
No objection, Your Honor.
Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty. The court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, it was kind of a tough decision for Mr. Geary to come to, but he thinks it's in his best interest, and he would ask the court to go along with the plea bargain that it's taken us quite some time to negotiate, but I think he wants to get this behind him. It's unfortunate that we've ended up here, but I think he is ready to move on and become a productive citizen once he gets this behind him.
All right, the court is going to sentence you to 5 years in the prison, give you credit for any time served. There's an affirmative finding of family violence. There's to be no contact with Anessa Nicole Guerra. There's a $1,500 fine. State is taking in consideration 2025 AL 006681, 2025 PF 31338. And this will run concurrent with 2020 CR 12202. And there's to be no unsupervised contact with minors. Is there anything else with regards to sentencing?
No, Your Honor.
Just whenever we're finished with this and the MTR, we have the victim president who wishes to do a victim impact statement.
Okay. All right, we're proceeding with 2020 CR 2202. Are you the same Juan Carlos Aguirre Jr. who was placed on deferred adjudication in 2020 CR 12202
Yes.
for the offense of assault, family choking, strangulation on March 3rd, 2021 for a period of 3 years? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor, violation of condition number 15, on or about the 12th day of May 2021 in Bear County, Texas, the defendant, Juan Carlos Aguirre Jr., did then and there fail to attend, comply with all rules, regulations, instructions, and financial agreements as directed by the court and or supervision officer and or the head of or authorized personnel of the following counseling education program, state accredited battering intervention and prevention program, in violation of condition number 15.
How do you plead to that? True or not true?
What's especially difficult to wrap your head around is that this was a second offense against the same person. Yet the discussion shifted to whether the sentences should run at the same time. That's hard to justify. If someone is already on probation for seriously injuring another person and then repeats that behavior, it raises a serious question about accountability. Situations like this usually show the system that the first sentence didn't work. This kind of case can be discouraging for victims, especially when someone is given multiple chances and continues down the same path. If there's ever a time when back-to-back sentences make sense, this would seem to be it. Do you think serving time concurrently is reasonable in cases of repeat violence?
State will waive the remaining violations, Your Honor.
Any objection?
No objection.
Did you understand by pleading true to violation of condition number 15, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition 15?
Yes, ma'am.
Court will find violation of condition 15 true. Is there a proposed agreement?
There is, Your Honor. That is to revoke the defendant's probation, adjudicate him guilty, and sentence him to 5 years TDC.
All right, so why should I give him 5 years? Because the complainant in this case is the same complainant that he has the new case on. And so why should I do this?
Judge, if we're speaking about this probation, this deferred adjudication, Mr. Geary was doing the things he was supposed to be doing at the time. He was enrolled in BIP. In fact, if you look at the records, I believe he did all but 4 classes of the BIP. But because of other circumstances, the MTR was filed on him, and he did not complete it. There was some other things going on in his home life and stuff. I believe had some family health issues and stuff, but he was doing the things he was supposed to be doing. He just didn't complete it because of the circumstances. So that makes him not a good candidate for probation. But I don't think to punish him in excess for something that's occurred after this probation expired is fundamentally fair on the original deferred.
No, I mean, because he hasn't learned anything. And I don't know what's happening in his relationships, but it doesn't appear he's learned anything. And I don't know why I should sentence him to just 5 years when he's been sentenced on assault family household member with a previous conviction, which means there's a previous conviction, and it's against the same complainant that he's on probation for. State, why should I give him 5 years?
It just seemed that in the best interest, considering, yes, it's the same victim, but for efficiency of judicial purposes for both cases to run concurrently together.
All right, this is what the court is going to do. The court is finding 15 true. The court is going to grant the motion, find you guilty, revoke, sentence you to $1,000 fine, time and money run concurrent. There's an affirmative finding of family violence. This will run concurrent with 2025 CR 011524. There's to be no contact with Anissa Guerra. There's to be no residing in a household with minors. There's to be no unsupervised contact with minors, and the court is going to sentence you to 8 years in the prison. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes, for the most
You
part.
do have a limited right to appeal. That right to appeal is that as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Because this is an affirmative finding of family violence and a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, you're gonna have to start making better decisions. Otherwise, you're gonna find yourself in and out of somebody's prison. You understand?
Yes, ma'am.
And your relationship with her is over.
Oh,
You
yes,
understand?
ma'am.
All right.
Personally, 8 years still feels low when you consider what the victim went through. Twice. That said, Judge Boyd going beyond the original plea deal sent a clear message that this wasn't being treated as a one-time mistake. It's a reminder that when harmful behavior becomes a pattern, the court eventually draws a firm line. More than anything, I hope the victim finally gets peace and distance after this. No one should have to live in fear, especially when the danger keeps repeating. And while 3 additional years might not sound like much at first, that is a significant amount of time when you're sitting alone, reflecting on your actions, with a possible maximum of 10 years on the table. I'd like to know what you think. Was 8 years the right call, or should the judge have gone all the way to the maximum sentence? Thanks so much for watching. Be sure to like and subscribe. Your comments and feedback genuinely help me improve these videos, and I appreciate every single one.